lights off. How was this? Did I pass the test? Thank you. Thank you, Chair Tepper. My name, as you said, is Joan Foster Evans. I'm the General Counsel of the Energy Facility Siting Board. I'm joined today with several of our members of our team. Andrew Green, who's sitting with you, who worked hard on these regulations. Daniel Kelleher, one of the attorneys in our siting division. And Tim Riley, a senior analyst with siting division. Together, we will be presenting the cumulative impact analysis and site suitability criteria provisions of the 2024 Climate Act. First, I'd like to thank everyone for the hard work to get here today. This was a real team effort by a lot of people to get to this meeting. First, I'd like to discuss briefly how we got to this milestone, and then I'll turn the presentation over to others. The tentative decision before you and the decision that the board issued in September goes into quite a bit of detail about the 2024 Act. However, in order to keep in mind the context and goals of the 2024 Climate Act, as we review this regulatory package, I will provide a short history for context. As we know, Governor Healy signed Executive Order 620 in September of 2023, which established the Commission on Energy Infrastructure, Siting and Permitting. The Siting and Permitting Commission was tasked with reducing permitting timelines, ensuring communities impacted by energy infrastructure have input into the siting and permitting of such infrastructure, and ensuring that the benefits of the clean energy transition are equitable. The Siting and Permitting Commission included a broad array of stakeholders, including representatives from labor, environmental justice, economic development, housing and real estate, environmental protection and land use, agriculture, local governments, electric utilities, and the clean energy industry. The Commission submitted recommendations to Governor Healy in March of 2024, and many of the recommendations from the Commission's report were enacted in November of 2024 into the 2024 Climate Act. The new law, which we refer to as the 2024 Climate Act, or just the Act, reduces the time for permitting through a consolidated permitting process, adds requirements for engaging with impacted communities, and will contribute to an equitable clean energy transition. We anticipate that there will be an increase in the number of clean energy projects that will seek siting board approval in the coming years. The 2024 Act directs the siting board to issue consolidated permits, including state and local permits for clean energy infrastructure facilities. Facilities that are small clean energy infrastructure facilities will typically seek a consolidated local permit from a local government. The proposed regulations, together with proposed regulations from the Department of Energy Resources, the Department of Public Utilities, as well as guidance documents from EEA, are integrated parts of a program to fundamentally change the siting and permitting of energy infrastructure in Massachusetts. The new provisions apply to clean energy infrastructure facilities, and some of the new provisions will apply to the siting board legacy facilities that are not included in the clean energy definition. The proposed regulation also include improvements in the way the board conducts its business in order to efficiently and effectively review and decide siting applications. I would like to note that there are several related proceedings underway simultaneously to implement the Act. There is this siting board proceeding, docketed as EFSB 25-10, which was opened on September 12, 2025. This proceeding proposes to revise 2 chapters of existing regulations, add 4 chapters of new regulations, and repeal 5 chapters of regulations. There are two separate proceedings at the Department of Public Utility, one focusing on new intervenor grant support program at 220 CMR 34, and a new rulemaking about to be opened focused on siting board application fees at 220 CMR 32.00. The Department of Energy Resources has proposed regulations governing consolidated local permits at 225 CMR 29. And then there's 3 guidance documents issued by EEA: the guidance on site suitability for clean energy facilities, the OEJE standards and guidelines for cumulative impact analysis, and the OEJE standards and guidelines for community benefit plans and community benefit agreements. Now, the Siting Board is proposing a 5th new chapter of regulations, the regulations that are before you at 980 CMR 15.0. I will now turn to the Act's provisions that specifically addressed the cumulative impact analysis and site suitability provisions. First, the Act contains 2 provisions that require the board to consider cumulative impacts or impacts of a project on the community in which the project is proposed to be sited. The board's statutory mandate, General Laws, Chapter 164, Section 69H, requires that any determination by the Siting Board include findings that due consideration has been given to cumulative burdens on host communities and efforts to avoid, minimize, or mitigate such burdens. In addition, the Act includes a cumulative impact analysis provision that has several requirements. It requires that each applicant must determine first whether its project is to be sited in an area that is subject to an existing unfair or inequitable environmental burden or related health consequence, and if so, whether the environmental and public health impact from the proposed project would likely result in a disproportionate adverse effect on the area or would increase or reduce the effects of climate change on the area. We will be discussing all the pieces of that definition shortly. If the project is likely to result in a disproportionate adverse effect on an area, the applicant must propose potential remedial actions to address such disproportionate adverse effect to the environment, public health, and climate resilience of the area that may be attributable to the proposed project. So that's quite a mouthful here. In order to effectuate the CIA requirements, the Act requires actions by various different entities. First, the Act requires that OEJE develop standards and guidelines governing the potential use and applicability of CIA in developing energy infrastructure. Undersecretary Power will be discussing that in a few moments. The Act requires the Siting Board to develop standards for applying the cumulative impact analysis standard and guidelines developed by OEJE. The Act further requires the Siting Board to promulgate regulations for cumulative impact analysis as part of its review of legacy facilities, large and small clean energy facilities, and that such regulations be informed by the standards and guidelines issued by OEJE. Finally, regarding CIA, the Act requires each applicant for either a consolidated permit or each petitioner filing a petition to construct to include in its application or petition a CIA report. Turning to the site suitability provisions, the 24 Act includes provisions related to the suitability of sites for clean energy infrastructure facilities. I will note that this provision does not apply to the legacy facilities, the same way that the CIA provisions do. So first, the Act requires EEA to establish and periodically update a methodology for determining the suitability of sites for large and small clean energy facilities and some limited number of transmission and distribution facilities. The Act further requires EEA to require project proponents to avoid or minimize, or if impacts cannot be avoided or minimized, mitigate siting impacts, environmental and land use concerns. Undersecretary Judge will discuss this in a moment. The 24 Act requires the Siting Board to establish standards for applying site suitability criteria established by EEA to evaluate the social and environmental impacts of proposed clean energy infrastructure facility sites. The Siting Board standards must include a mitigation hierarchy. And finally, the Act requires DOER to establish standards for applying site suitability guidance from EEA to small clean energy infrastructure facilities, which it has done. So this is the framework the framework within which staff developed the CIA and site suitability regulations and guidance before you. A few comments on the regulation development process. Throughout the regulation guidance development process, staff's overall approach has been to introduce preliminary thoughts on what is necessary to implement the siting and permitting provisions of the 24 Act. Then staff developed straw proposals, conducted formal stakeholder meetings, attended many informal stakeholder discussions to refine the outlines of the 24 Act implementation prior to opening the formal rulemakings. Over the regulation process, meetings and comments have led to significant revisions of the draft proposed regulations and guidance. Siting Board staff will discuss some of those comments and changes later in the presentation. The Siting Board's decision to open the rulemaking, moving into the formal rulemaking process, was issued September 12th and includes a description of the extensive outreach conducted during the development of those regulations. In the September 12th decision, the Siting Board proposed a number of changes to its regulations and included 4 new chapters of regulations. Since the September decision, the Siting Board staff have conducted 4 public comment hearings over different parts of the state and have received extensive written comments on the proposed regulations that were issued in September. Staff are considering those comments and will present recommendations early next year. Over the development of the CIA and site suitability regulations and guidance, staff have coordinated extensively with OEJE, EEA, and DOER, plus numerous discussions with other affected agencies. We saw significant stakeholder input. And that coordination started in early 2025. During the spring stakeholder meetings that I mentioned earlier, the Siting Board conducted a stakeholder meeting specifically on CIA with OEJE in May of 2025. OEJE developed draft guidance on CIA during the summer and fall of 2025. In addition, EEA developed draft guidance on site suitability during the same time frame. Both guidances have been released for public comment, and OEJE and EEA have conducted multiple informal stakeholder meetings regarding each guidance document, most of which were attended by Siting Board staff. In addition, EEA conducted a site suitability webinar on October 9th. The Siting Board issued its draft proposed regulations on CIA and site suitability for discussion purposes on October 31st, 2025. The Siting Board staff, along with staff of OEJE, conducted a virtual webinar on November 6th, at which staff provided an overview of the CIA guidance and Siting Board proposed regulations. The Siting Board also accepted written comments on the draft proposed regulations and guidance. Siting Board staff now recommend opening a formal rulemaking on the new regulations 980 CMR 15. And staff note that the TD and draft proposed regulations before you are the first step in the formal rulemaking process. There'll be further opportunity for public comment and board member input. So I'd like to touch base on what the rest of the staff's presentation is going to look like. First of all, I note that Undersecretary Judge will present the site suitability guidance. Undersecretary Power will present the CIA guidelines, including a discussion, extensive discussion on the MES, the Mass Enviro Screen. Then EFSB staff will present the CIA regulations, which will include the respective roles of CIA and site suitability, the steps in the CIA process, how to determine whether a project creates a disproportionate adverse effect, and appropriate remedial actions for any disproportionate adverse effect. Staff will discuss the contents of the CIA report, how the board considers the CIA and site suitability reports, and finally, staff will discuss comments that we received during the informal development of the draft proposed regulations and how we address those comments. Thank you. I'm glad to take questions at this point, or we could take questions after staff do the rest of the presentation. Or would you like us to keep moving along? Okay, thank you. Undersecretary Judge.
Okay, great. Now, I think it is. Okay, great. Well, thanks, Joan. So I'm just going to cover a few updates to the site suitability guidance that we've proposed. I don't think the whole thing is on here. I don't think you can see the full slide for some reason. Cut off at the bottom, but I'll let you work on that. In the meantime, I can start. Okay, so so Joan did a good summary of site suitability guidance and what we're required to do. We got a lot of comments on this. We've had a lot of meetings over the last couple of months. We probably received I don't know, over 100 different comments. Probably there's 400 different things in our tracking spreadsheet, so I can say that at least. And so we've been going through those and coordinating with DOER and the siting division staff to incorporate this into their various regulations. And there were certain decision points that we needed to make before we finalized our guidance, just because of the timing of when DOER's regulations needed to move and the CIA and site suitability regulations needed to get put before you all. So some of the key things that you'll see reflected in the regulation are listed here. So first of all, I think this was a big decision point. We got a lot of comments on this. In the initial guidance, we said that facilities that were required to conduct a cumulative impact analysis were not also required to perform a site suitability analysis. And I think at the time we weren't sure how detailed the process for conducting a cumulative impact analysis, or we weren't sure what the process was going to be for either, but we weren't sure how detailed the site suitability process was going to be and how much work that was going to entail. And we were worried there was a lot of overlap between the two. As the two things have evolved, I think some of our thoughts around this have changed a bit. And we also got a lot of public comment saying that facilities should not be exempted from site suitability. So we've changed it so that facilities that are required to perform a CIA analysis are also required to complete a site suitability analysis. Notably, most utility infrastructure is going to be exempt from site suitability already because of the way the statute is written. So this will apply primarily to large generation facilities, large storage facilities, and utility infrastructure sited in newly established public rights of way. The next thing, which is in part why we felt a little bit more comfortable making some of this change, is we've gotten some more clarity around the functionality of what the site suitability mapping tool can do and how it will work. So in some conversations with our IT and GIS teams, we have gotten confirmation from them that they can structure the mapping tool in such a way that you can draw the outline of a project or import a shape file and have it automatically calculate the scores. So there's not a need for a third-party score reviewer or manual processing here. This is going to be a relatively easy process to obtain a score from the mapping tool that we'll have. And that also eliminates the need for a third-party score reviewer, which was originally envisioned in an earlier draft of the regulation. And then in terms of the pre-filing and application requirements, not too many changes here, but in the pre-filing, we expect that applicants will show their anticipated criteria-specific scores. So this is the scores for carbon sequestration impacts, biodiversity impacts, agriculture, climate resilience, social and environmental burden. So all the categories that we're scoring projects on. They'll have to say, these are what we anticipate the scores will be, but making clear this is not final. And they'll have to provide that in stakeholder meetings during the pre-filing process. And then when they submit an application, they'll have to provide what we're referring to as a site suitability report. And so this report is going to include the final scores, any proposed mitigation, any proposed benefits that the project's going to be offering, any other context they want to provide. So this will be something that the siting division develops a template for in consultation with EEA. And that will be provided as part of the application in a fairly standard format. And then the process for conducting any reviews of those scores, if someone was questioning that, is also spelled out in more detail in the regulation. So an applicant, a local government, or any key stakeholder can, within 30 days of an application being submitted, request that the EFSB director review some of the underlying scores. They can only make this request, though, and adjust or scores can only be adjusted if there's materially erroneous, incomplete, or otherwise faulty data. So they would have to demonstrate that the underlying data used to calculate the score was inaccurate or incorrect in some way. And then within 30 days of the receipt of that request, the director shall issue a final decision. So within the first 60 days of the proceeding, we'll have a final answer on what the scores are that are going to be evaluated by the board. So trying to get that out of the way early in the process. So those are the changes you'd see reflected in the regulation. If you go to the next slide, we are still finalizing some other elements of our guidance that will impact all of this. In the guidance, in the initial version of the guidance, there's a discussion of criteria-specific scores and the total score. We had a lot of confusion from people around the use of the total score. We're proposing potentially eliminating that and really focusing on the specific impacts of the project. But when you do that, it does impact some other things. So we have to change how you apply some of the score modifiers. So there was ways that you could lower your total score by offering certain project benefits. We're trying to figure out how to integrate those two things right now over the next few weeks. And then additionally, we're taking another look at the use of climate resilience standards, the specific data set that we're using. We got a lot of people questioning, what's the purpose of this? Why are we being measured against these specific impacts? We're not necessarily contributing to a flood risk. Why are we being scored poorly for being in an area that has a flood risk? So trying to clarify that a little bit. Also clarify the avoid, minimize, mitigation hierarchy and how that will be applied based on the scores that project receives. So a little bit of clarification there. We're clarifying what constitutes newly established public right-of-way. I think people were questioning, what does newly established mean? Is there a cutoff date? So we got a lot of comments suggesting February 18th, 2025 as the cutoff date. That's the date that the act became effective. So probably what we'll put in the guidance. We're looking at scoring for projects whose site footprints intersect with protected open space, particularly Article 97 land. We got comments saying that these projects shouldn't be necessarily scored very poorly if they're not having an impact to the land. An example of this could be an offshore wind facility that is sited under a beach that is Article 97 land that does not disturb the actual beach. Yes, the line actually intersects that property, but it's not actually having an impact to the actual protected open space. So potentially allowing some kind of waiver in situations like that. And then I think just clarifying a little bit how the guidance intersects with other state environmental protection laws. There's a lot of environmental laws, as you all know, on the books that still apply to all these facilities related to wetlands and water resource protection and habitat, and noise and air pollution. This guidance does not replace those, and I think we just want to clarify that. This is complementary. This looks at different components that are statutorily required, but it doesn't replace those. And so we're finalizing this over the next few weeks, but these are a few of the other issues that are still under discussion. Happy to take any questions. All right. None. I think.
Thank you.
Power, you're next.
Can you hear me? Great. Hi, everyone. My name is Maria Belén Power, and I'm the Undersecretary of Environmental Justice and Equity at EEA. You could go next. So the Climate Act that was mentioned, it charges the Office of Environmental Justice and Equity with two major responsibilities. The first is implementing environmental justice principles across all of EEA. And secondly, developing guidance on cumulative impact analysis for the board's siting and permitting process. The Office of EJ, Environmental Justice and Equity, otherwise known as OEJE, has been working very closely with the DPU Siting Division staff to establish the CIA cumulative impact analysis guidance. We've held several stakeholder meetings, focus groups, and done extensive outreach on what other states' models are to inform and refine our process. We have developed a mapping tool, which is going to be the bulk of this presentation, that is called the Mass Enviro Screen, or MES. And it will be an important component to this process and ensuring that communities across the state are evaluated in a consistent way. A draft of the MES, the Mass Enviro Screen, was released for comment alongside the proposed draft CIA guidance and regulations. And today, our section of the presentation will focus on the tool, the feedback we've received, and the changes we have incorporated. You could go next. So the tool was designed to fulfill the key component of the cumulative impact analysis as written in the statute. And I'll just read. The cumulative impact analysis is a written report produced by the applicant that assesses impacts and burdens, including existing environmental burdens and public health consequences in the specific geographical area where a facility is proposed. Now, if the analysis shows the area is subject to unfair or inequitable environmental burden, or related health consequences, the report must identify three things. One is whether the proposed project will likely result in a disproportionate adverse effect, how the proposed project could increase or reduce the effects of climate change in that area, and proposed remedial action to address any such disproportionate adverse effect attributable to the proposed project. Next. We could go, yep, thank you. So a cornerstone of the report will be for project applicants to identify whether an area is subject to unfair or inequitable environmental burdens or related health consequences. Now, to ensure that across the state and between applicants, to ensure consistency, OEJE has developed the MES, the Mass Enviro Screen. So it integrates 30 different indicators across 5 major components to produce a single cumulative burden score. The higher the score, the greater the combined environmental and social vulnerability of that area. Now, communities will be designated as burdened area if they meet one or both of the following criteria. The cumulative impact of the Mass Enviro Screen is at the 75th percentile or above, or an annual median household income that is 65% or less of the statewide median income. Now, at the core of the Mass Enviro Screen analyzes the intersection. I think we can go next. Nope, that's it. Yep. The intersection between climate and pollution burdens and population vulnerability. But this can be further broken down into the 5 major components that we see here and categories of indicators. So the first 3 components describe the types of climate and pollution burden that communities experience. This includes environmental exposure, which are based on measurements of different types of pollution that people may come in contact with. Environmental effects, which are based on the location of toxic chemicals in or near communities that can cause adverse environmental conditions. And lastly, climate risk indicators that speak to a community's level of exposure to climate hazards. Now, the last 2 components are what are considered to be population characteristics and describe the conditions that can make people or communities more vulnerable to those burdens. Now, the first one is sensitive populations that are indicators which measure the prevalence of physiological or health conditions in a community. And the second is socioeconomic factor, which are conditions that may increase people's stress or make healthy living conditions difficult and decrease capacity to adapt. We could go next. So this slide, very crowded, but as mentioned before, it will be available online. You can see the 30 indicators which inform the MES and the final score. So as you can see, they're separated into the group components by pollution and climate burden and population characteristics. In terms of pollution and climate burden, we have environmental exposures, which include things like pollution, particulate matter, or PM 2.5, and ozone. Under environmental effects, we include things like proximity to hazard waste sites or impaired water bodies. And under climate risk, we include indicators like flood risk and extreme heat. Now, sensitive population indicators capture health factors, such as rates of pediatric asthma or premature mortality and others. Now, under socioeconomic factors, we look at things like linguistic isolation, rates of poverty, and unemployment. Now, on the beta version of the MES, there's a technical documentation which describes every single indicator in detail, as well as the rationale for including them. Next, please. So on this slide, you'll find methodology for calculating the final score. First, for each of the 30 indicators, we calculate a percentile rank across all census block groups. Next, those indicator percentile ranks are averaged together within each component. So we get an average score for environmental exposure, environmental effects, climate risk, and so on. Then we group these composite scores into 2 main categories. The first one is pollution and climate burden, and the second one is population characteristics. Now, to generate the final cumulative burden score, we multiply the burden score by the population characteristic score. The result is a single value that represents the overall environmental and social burdens for each community. Now, these cumulative burden scores also represent the percentile rank, which means that a community score also indicates the percentage of the scores in a group that are equal to or higher than a given score. I need to pull up the other slide. One second. Right, so this is some of the feedback that we heard. The overlapping indicators. So we heard that some indicators seem to be overlapping. And while there is high correlation, there is not necessarily overlapping. So for example, PM 2.5 and diesel particulate matter as compared to traffic proximity. So they measure similar things where there might be overlap, but we're not creating a direct relationship. Rather, they are highly correlated. Now, the data coverage and geospatial resolution, there are data sets that are aggregated at larger geographical scales. For example, census tracts. Now, I should have brought some water. Now, the temporal limitation database are the indicators. Some data is older and it doesn't reflect actual local conditions. Other example is the EPA EJ screen that are now only accessible via archive versions. And then the suggested additional indicators are the ones that we are considering. For example, concentration of clean energy infrastructure. Wish I had some water. Is there an extra? Thank you. Suggested additional indicators, which are environmental effects, such as a clean energy infrastructure. Great, thank you, Commissioner. So the suggested additional indicators. So we heard a lot from communities about the need for showing the concentration of clean energy infrastructure. And then lastly, sensitive population. So we also heard from communities, but also public health experts around the need to include age and disability and adult asthma, among others. But those were sort of the two main feedback around additional indicators that we should include. And so we are considering those right now. Next. Now, the way in which we've addressed some of those is the indicator correlation question, as I mentioned. They are intended to capture the full picture of community stressors, not duplication. So while it seems like some of them are duplicating, they're not actually duplicating because they measure different conditions. Now, data coverage and geospatial resolution, the MES uses census block groups, which provides the more granular data than tools that rely on larger geographical units, such as census tracts. Now, this approach aligns with the best practices for cumulative impact analysis that are being mapped across the country. Balancing, thank you so much. Balancing detail, the detail that we want, as well as the data availability. And so the CIA guidance and regulations creates, we are developing a pathway for communities that are not considered burden areas to request a cumulative impact analysis. So the request would not be to be considered as a burden area, but rather to be able to request a cumulative impact analysis. The other piece was the data timeliness. And so some indicators do employ older data sets from various years. But the idea and sort of the spirit and what we will do is to use the most current available data. Finally, the socioeconomic weighing. And so this really informs the vulnerability, separate indicator thresholds, especially in central and western Mass, where population density may not be reflected because of, the indicators may not be reflected because of the population density or lack thereof. And so there is a separate income criterion that is applied to ensure that rural communities that are experiencing high poverty are identified. Like I said, since the high correlation between pollution and climate burdens and dense population could otherwise understate the rural vulnerability. And finally, the updates that we're making are around the increased transparency. So we did hear that there was room for improvement around where the data was coming from. And so the technical documentation will be more clear in discussing the limitations of the screening tool, like MES, which are very similar to the limitations of every screening tool. And now these limitations are consistent with other tools and are widely agreed to not be grounds to forego the tool altogether. And like I mentioned before, the community petition pathway, so communities not designated as burden areas who would otherwise not be required, the project proponent would not be required to do a CIA. These communities could request that a CIA be conducted. So right now we are developing that mechanism for communities to be able to do that if they are not designated as burden areas. And finally, I'll just close with saying the Mass EnviroScreen is intended to be a starting point that flags areas for further analysis, rather than serve as the sole determinant of cumulative impacts. Decisions will require project-specific analysis and the board's assessment as detailed in the full cumulative impact analysis process. And I think I'll pass it to you, Joan. Tim, there we go.
Good afternoon. Daniel Kelleher, siting board staff. There we go. So some of this information is going to be a repeat, but sometimes we need to hear repeats. So these are important dates regarding the timeline. There are many dates associated with the timeline of promulgating these regulations. The first 3 dates have already happened, and those are part of the informal process for creating these regulations. Dates 3, or the 4th date is today. Today starts the formal rulemaking process, and it envisions that the board will file proposed regulations with the Secretary of State on Friday of this week. And then 2 other dates highlighted on this sheet are the public comments, both in the form of 2 hearings in early February, and also the opportunity for written comment, also due in early February. Next slide. So the goals of the presentation, and I know our general counsel highlighted a number of these, but in general, the goal is to discuss the integration of cumulative impact analysis and the site suitability guidance that the board will use in adjudicating energy facility applications. Numbers 2 and 3 are to describe and illustrate the CIA process and also the CIA report that the regulations envision that the applicants will file. We will also discuss and summarize the comments that we have received and the specific revisions that we have made to the draft proposed regulations, and instances where there were significant comments that we haven't proposed changes to the regulations. And then finally, there will be an opportunity to respond to questions and comments that the board has. So with that, I'm going to turn this over to my colleague, Tim Riley, to dive into many of the details of CIA.
Thank you, Daniel. You all have made my job particularly easy, so we won't have to take as much time. So thank you all. I'd like to start with a discussion of the complementary roles. A logical question that has been asked all along is how does site suitability and CI, how do they fit together? Are they redundant? Are they repetitive? Are they mutually exclusive? What are they? And what we found over time as this has evolved is that the nature of the indicators, the data sources, how the data are used are really quite complementary. And what that does is that allows for a much more holistic way of looking at the manifold potential impacts of a major energy project in the Commonwealth. So at this point, we look to CIA and site suitability as complementary processes that fit nicely together to really give a much more comprehensive depiction of what the impacts of potential impacts from a facility are. And next slide, please. In terms of the data used, the outputs and things like that. Now here on this slide, we look at, basically here are all the different types of indicators that are used and looked at under both site suitability and CIA. And you can read those, I'm not going to go into them. But basically, again, what this does is that by putting these together, and we kind of struggled at first how this should all fit together. But by putting this together, what we've really found is that it tells a much more expanded and comprehensive and holistic picture of the impacts. And it covering everything from within which I really like, is the life cycle of a project. Everything that starts with, is this plot of land even appropriate, suitable for a project like this? What about impacts from construction? What about the actual operations and potentially even decommissioning of the project, in 70 years or 100 years? So what we do, what we like is that we've put this together in a way, sort of a puzzle pieces, put this together in a way that tells the whole story. Next slide, please. Okay, and Undersecretary Judge has made my job very easy in describing how this is used, so I will not take a lot of time, except to say that basically the way that the regulation is constructed is that for clean energy, and this is for just clean energy here, for transmission, distribution, energy storage, energy generation, it all requires basically a CIA report. And that if there's disproportionate adverse effects, and we're going to talk about that in a second, then that requires some kind of remedial action uniquely to address the cumulative impacts. This is not, and I think that's a really important point here. This is not just the sort of pedestrian remedial actions and restoration mitigation that's used, generally speaking, for energy projects. This is sort of the unique above and beyond incremental for cumulative impacts, what remedial actions are necessary. And so remedial action will be necessary if there are some kind of disproportionate adverse effects, as you indicated, Undersecretary Power. And for site suitability, again, you've made my job much easier. Unless there's a new right-of-way, site suitability really wouldn't be used for clean transmission distribution, but it would be used for clean energy generation and storage for most projects, except for the really small projects. And I can get into the numbers, but we can look at the reg for that. Next slide, please. Now, for fossil fuel, it's a much different story. CIA is always required, but basically site suitability is not required. That's correct, yes. Good. Yeah, per the statute, exactly. Next slide, please. So what kind of implementation and are we talking about here? And you know, one thing I have to say, I compliment the site suitability and EEA in really coming up with excellent advances in how they have constructed mechanically and on the web the site suitability mapping tool. I mean, it's an excellent piece of work that basically does, as Undersecretary just said, calculate everything. So this makes it really quite straightforward for folks and applicants to use. So that was an excellent tool, kind of like how CIA uses massive virus screen, and that's another great tool for CIA. But basically, and I won't go into it anymore, except that there is the social modifier that Undersecretary Judge mentioned, and basically, you know, the board can modify the scores, but it does take an agreement mutual written agreement between the applicant and the local government. So it's not just the board modifies it; the board gets a request. And if there are, in fact, certain environmental benefits per the guidance that are provided, as long as the applicant and the local government agree on it, then the board can consider modifying that score. So it does take, and that took me a while to really understand, but I think that really actually makes a whole lot of sense, that you want the town to basically also agree to this too. I thought that was a very good addition. Next slide, please. So let's talk about the CIA process itself, and that's sort of the engine that runs this whole thing, basically. Each step is summarized. We're going to summarize it, and the applicant, just like say for site suitability, using massive virus screen and CIA process, the applicant's got to do it. And for illustration purposes, we're once again going to use this little project, underground transmission project between Sudbury and Hudson. We talked about that in November. We keep using this project. It's an easy way to illustrate how this works, basically. Next slide. So step one. Step one is to identify this so-called specific geographical area of the project. And that was called for in the law, in the 2024 climate law, but it was never really defined. And it's basically a buffer area around the project. And the way that the regulation reflects that is that we have identified, the board identifies basically different radial distances from the so-called facility boundary. Well, what's that? Well, the facility boundary is the outermost boundary from construction or operation of a facility. And then there's this so-called this buffer area or this radial distance that emanates from that. And that whole thing, from the facility boundary out to with this radial distance, that is the specific geographical area. And it really varies between types of projects. For example, for a transmission distribution line, it's only a quarter mile from the right of way, because it really reflects. And then why is it? But for a major air permit, for a gas fossil generating facility, it's 5 miles. And that's, of course, required by the law. But the reason, the logic and the reason that it's so different is it reflects from our decades of experience with these kind of projects what the expected impacts are. And so we identify basically different types of impacts. For example, for a large or a small energy storage facility, you have noise, heat effluent, and that will radiate past the facility boundary. And basically, there's also potential, of course, with storage. We know that with battery storage these days, there's a lot of concerns. And so that basically you have a situation where in an emergency situation, you're going to get potentially impacts outside that initial boundary. So that basically is the reason. So in other words, there's a lot of logic goes into, for each type of facility, how far out do we think the effects are going to be? That's what's reflected here. And we've tried to, with comments received, we've tried to reflect how, the best logic for that. Next slide, please. Okay, so once we've identified this specific geographic area, then it's basically an overlay analysis. And this is where the mass enviro screen tool comes in very nicely, is to basically say, well, if there's a burdened area, and these, again, the burdened area map is pre-existing. It's based on all of the massive fire screen information, and it's in where are these burdened areas. And then we look at where a project-specific geographical areas for a noticed route or site. And those are the preferred route, the notice alternative, the notice variation, the ones that we really think we're going forward with. It's not all 86 routes or sites. That would be really a lot more work that's necessary. It's really the main ones they're thinking about looking at. And so we basically do this overlay analysis, and as Undersecretary Powers indicates, you are coming up with a nice package to either upload shape files or export the data onto the applicant's map. So that makes that a lot easier too. And I think an important thing though is key stakeholders that can say, well, this area hasn't been identified in a pre-existing mode as a burdened area. They can petition and say, hey, we think our area should be burdened because either erroneous data or some kind of compelling reason. But it's got to be a census block group that touches the SGA. It can't be way out far away, and it can't be. One of the comments that we got was, especially from maybe some of the central and western more rural areas, is we like our entire community to be considered a burdened area. Well, yeah, certainly can understand that, but it really has got to have some nexus to the actual project itself. So next slide. This is just an example. This is that Sudbury Hudson project, and you can see kind of looks like a barbell has had a bad day. It's got two round things at the end. Those are the substation. And then we have the specific geographic area for that are different sizes for the transmission line. And in this case, you can see the kind of pinkish, brownish color. Not sure exactly what that is, but those are the burdened areas. You can see that there is overlap in the northwestern side. So that is actually an overlap of a burdened area with a specific geographical area. That would be the area we would do the CIA, basically, unless there was like a petition somewhere else. But in this case, it was that one burdened area. That's example. Next slide. Okay, so for that little burdened area, for those little burdened areas, then we record the indicator values from mass and virus screen. And there's that little map again, this little chart of all of the indicators. It's not really important right now, except that within the burdened areas, we look at what the value of the indicators are. And then next slide. We look at which ones are elevated and which ones hit the 50th percentile or higher for clean energy. And because of ongoing concerns for operations for fossil fuel, we consider all indicators within burdened area for a fossil fuel facility to be a quote unquote elevated indicator. Next slide, please. So now we have the burdened area that overlaps with the SGA. We've identified these so-called elevated indicators. Then now comes the work of identifying what are the project impacts on the elevated indicators. And we look at all the things that are sort of normal for impact assessment. What's the nature, what are the type of impacts, what's the degree, the spatial extent, the duration. So you kind of characterize what are the project impacts in these very special areas of overlap with burdened areas. And what we try to do is we try to apply, or we look for the applicants to apply qualitative or quantitative information. Where there's quantitative information, it's strongly recommended. So we want supporting documentation. We want a good argument for what are the impacts and why are they impacts. And we look at everything from benefits, positive impacts, no impacts. Maybe there's some de minimis, very, very small impacts, and negative impacts that are more than de minimis. And again, with all of this, we look for supporting documentation. Next slide, please. So to material exacerbate, which is a standard, to materially exacerbate an indicator that's an elevated indicator, we want additional impacts that are more than de minimis. That's very important here. There really has to be something notable here. And and so of course that's subject to all kinds of interpretation, isn't it? So what we try to do is we try to help walk through with an applicant kind of questions and issues that they should address that would identify a particular impact as materially exacerbated. And for that, we have examples of such considerations on the next page. And this is in your, by the way, we have an example, a template, a proposed template, and in Appendix B of that template are the considerations. There we go. So, these are things, none of these are a real surprise. Can you measure these impacts? And what's the duration and the frequency? Obviously, a longer duration and a more frequent impact is worse than a low duration and an infrequent impact. This one I thought was a really good was, you have an area of impact. Does the project actually increase the area of impact? I mean, are you actually expanding that area of impact? And I think importantly, we look at resiliency. I mean, how does this make this indicator less resilient? This, for example, with climate change issues like flooding and extreme heat. Are you making this less resilient? And what would be the recovery rate? Is this something that's going to, you're taking down a bunch of trees and you're making a heat island, and it's going to take 50 years to recover, or it's going to take maybe 50 weeks to recover? That starts really mattering in terms of understanding if something is materially exacerbated. And, does this project impact the public health in some discrete way, noticeable way? So those are the kind of things, and there are more, we just use these as examples, that an applicant would need to address to say, is this materially exacerbated? Okay, next slide, please. And so this is an example. These are a bunch of, this is that Sudbury Hudson line, and we look at a number of indicators that were elevated. And in this case, we look at the nature, the degree, the extent. We try to understand, is this a benefit? Is this a negative adverse? Is this no effect? And then of all these indicators, we find that because of construction and emissions during construction, there is, at least during the period of construction, there's a material exacerbation of the elevated indicator of particulate matter 2.5, microns, less than or equal to 2.5 microns, basically. So what do we do with that? Now that we know that there is an indicator that is materially exacerbated, next slide, we propose remedial actions. We basically say, okay, so this is a materially exacerbated, elevated indicator. So what are we going to do about it? And so we basically come up with, we use as Undersecretary Judge discussed, the mitigation hierarchy. We start with, can we avoid that impact? If we can't avoid it, can we minimize it? If we can't minimize it, can we mitigate it? And again, and I think this is a common thread throughout this whole thing. We look for supporting documentation, not, it's one thing to say it, it's another thing to actually try to prove it and to provide the supporting documentation. And so all of this requires supporting documentation. Next slide. Here's an example with PM 2.5, that materially exacerbated indicator. And we have examples of avoidance, minimization, and mitigation. You can read what they are. Electrification of vehicles for avoidance. We're building in an off-road area, so that minimizes traffic impacts. And the rail trail helps with reducing traffic, normal traffic. So that's a mitigation aspect. And again, we look for the applicant to provide additional information describing how this is right size. So not only is it important for them to come up with projects that somehow address it, but we really want to see a nexus to the impacts and a discussion of how is this right size? How is this in other fields we call, how is this scaled? Is this scaled appropriately to the impacts? Next slide, please. So all of this goes into the CIA report. And basically we have developed, again, it's in the TD. We have a template, and the template is also yet another affectation, another instrument, kind of like the site suitability mapping tool, the MES. This is another thing that makes it easier to implement for applicants. And by just sort of going through the template, you're addressing all of the kind of things, and they're listed there, the route to be assessed, the SGA, the elevated indicators, the burdened areas. All of that is addressed in the template. You just sort of walk through the template, and basically by walking through the template, you pretty much have a CIA report. And I think importantly too, that the report should also include community input. So, what they're supposed to do, the applicant's supposed to do during the pre-filing process, is supposed to be going out and talking to the community and soliciting information. What are concerns? And so the community provides those concerns. That should be reflected in here too. And with that, we're going to talk about the board review of the CIA and site suitability, and Daniel's going to do that. Thank you very much.
Thank you. Tim has just spoken about many of the requirements that the regulation envisions for the applicant. And then there are also requirements that the regulation would impose upon the board. This screen highlights a few of those requirements. A big requirement is that the board needs to ensure that the applicant in its CIA report has conducted a comprehensive analysis that complies with the various requirements. The regulation also requires, as required by statute, that the board consider that the board make findings regarding both that the applicant has appropriately and proportionally incorporated the mitigation hierarchy into its analysis, and also that it has given due consideration to the cumulative impact of the project. The regulation also requires that the board consider whether the applicant took reasonable efforts to consider and develop a community benefit plan or a community benefit agreement that incorporates cumulative impact analysis into its analysis and findings. So many comments were submitted from many, from utility companies, from renewable energy companies, from many others. They ranged from very broad in scope to very detailed. They were very helpful. They were thorough. These next two slides highlight some of the comments. So in some cases, the comments were such that we recommended making changes to the regulation in response to the comments, and that's what this slide highlights. Oh yes, so the first category of comments has to do with different treatment for legacy facilities rather than clean energy facilities, and the result of that comment is that the regulation envisions that there will be a more thorough analysis for the legacy facilities, in that the applicant must assess it across all indicators, not just elevated indicators. The second category is the petition for use of CIA in non-burdened areas. That has been discussed. The regulation employs a mechanism and a standard by which key stakeholders may request that an area that's not a burdened area, nonetheless, the applicant must file a CIA report with respect to that area. Expanded role for site suitability, that has been discussed. The changes are reflected in the proposed regulation, consistent with what Undersecretary Judge talked about and what Mr. Riley talked about. There was a request, so this relates to the last comment there, for the regulation to require a certain period of of reflection for the board to reassess its regulation. I think there was a request that it be looked at again in 2 years. The proposed regulation has it as 5 years. Of course, the board could undertake to do it sooner, but this was just this based comparative approach. So there was a request. Right now, the scoring is based on percentiles. It's not based on thresholds of what is safe or something like that. We left the approach as a percentile-based approach, which gives the board more flexibility. And sometimes it's very difficult to measure some of these impacts that we're talking about with precise threshold levels. There was also a request, and this is the second comment, that either the percentile amount be changed or that further explanation be given to that. The proposed regulation doesn't alter the percentile levels either for the determination of a burdened area or the determination of what an elevated indicator is. For the disproportionate adverse effects standard, the regulation continues to use the term materially exacerbate. And as Mr. Riley talked about, additional guidance has been provided in the CIA report template that helps to give the applicant more guidance as to how that is interpreted. I would say that phrase is still being discussed and fleshed out. There was definitely a request that some of the indicators be expanded to cover additional burdens that different communities may be experiencing. One example was a community that had 20 or so solar projects in that community. Ultimately, it was decided that the CIA wasn't appropriate for that type of a land use evaluation. And then there was a request that for adding indicators for board consideration. Undersecretary Power talked about that there is consideration being given to that, adding additional indicators. And then also, I would say on the very last comment, talked about the adequacy of the data that's underlying the MES, and that is also consideration is being given to that as this process unfolds. And at this point, that the regulation doesn't reflect that progress at this point, but it's going to be going on in tandem with the promulgation of these regulations. Next slide. Yeah, I thought that's where we were. So we're going to open up to comments from the board, and Ms. Evans is going to take the podium.
So at this point, we conclude staff's extensive presentation and would love to respond to questions from the board.
Okay, who wants to ask the first question? Commissioner.
Okay. I just thank you, everyone. Stacy Rubin. I want to just acknowledge how excited I am to be in this moment. I didn't want any more time to go by without acknowledging that this has been work happening well before the year that has happened, but also that staff and people across agencies have been working on this for, every single day. So I just want to thank you for all of that. And I do think that the integration of site suitability and cumulative impact analysis is going to make a very positive difference for how siting and permitting happens in the Commonwealth. So thank you for that. I can anticipate cases where an applicant is going to suggest that their project will not materially exacerbate an elevated indicator where there's an intersecting significant geographical area and a burdened area. And perhaps a municipality or a community group would disagree and say that there is a material exacerbation of that elevated indicator. So I'd like you to just kind of talk through the process that the board would use or the presiding officer would use to sort of deal with those conflicting opinions, and at what point would there be a sort of determination that may require the applicant to do a different analysis or update a CIA report to reflect what the municipality or community was saying?
Thank you for that question. So there's a couple different phases of project review, development and review where this question would come up. First of all, in the pre-filing stage, the applicant's required to present their CIA analysis, initial analysis to local community groups and to the local community in order to get feedback on that. I think if there were disagreements at that point in time, that's an informal way that those disagreements could be worked out. If the disagreements were not worked out, once the applicant files its application with the siting board would then take a look at the CIA report as attached to the siting board application. If the report were really materially insufficient, the applicant really didn't do the job, I think that there's a possibility that would be addressed in the completeness determination, as in that would be an incomplete application if the applicant did not actually do the analysis that they were required to do. If it were more of a close call, then that would be part of the adjudication of the project impacts, as the board would take a look at those project impacts, through discovery and hearings and briefing and that type of thing. And finally, the board would make findings in its decision at the end of the process. So I think that the adequacy of the CIA report shows up in multiple different phases of a project review.
That's very helpful. Thank you. And could you foresee during the discovery period, for example, the board essentially asking an applicant to update its report to further look into whether there's an elevated indicator that is exacerbated by the project?
During the project review, during the discovery process, certainly if staff thought there were insufficient information provided by the applicant, could certainly ask for additional information from the applicant at that point in time and during hearings also.
Excellent.
Obviously, if it required the applicant to go back and do some significant rework, we'd want to identify that earlier in the process, such as at the completeness stage.
Thank you very much. I can wait until maybe Commissioner Heupel and others have questions.
Thank you. I'll just echo the very well said thanks. I'm sure the chair and other members of the board and anyone who cares about this stuff recognizes how hard people have been working and developing some really cutting edge tools to make this doable in the real world. So thank you all. Lots of late nights, and they do not go unnoticed. It did sound from a combination of the mentions of this separate pathway for a non-burden community to request a CIA. That work is still underway on that. I just wanted to make sure that I'm understanding the broad strokes of how that could work. So if a community did not initially qualify as a burdened area, it didn't have enough elevated indicators to qualify, what is the applicant using to compare project impacts against? Is it the case that a non-burdened community that requests this could still have elevated indicators, just not as many elevated indicators as a burdened area? I'm just trying to think through how that works. So if you or others have further thoughts you can share on that at this point, that would be helpful.
So I could start. So the intent of the MES is to pre-identify the burdened areas based on indicated data. So the applicant, once they knew what the specific geographical area of their project was, what the outer buffer or boundary of that project was, and they put that polygon, and I'm going to get over my skis here. They put the polygon onto the burdened area map, the MES map. They're able to tell whether or not they're in a burdened area.
Right.
So the applicant would already know that by looking at the MES map and drawing their project onto that map.
Right.
So the intent of the provision to allow a community to say, hey, we're not on the burdened area map in MES, but we think we should be treated as a burdened area. There is a provision that's in the regulations right now. That particular community has to be part of the area of the The area SGA, thank you, the SGA of the project. So it can't be a community 3 communities over saying, hey, this community should be a burdened area. You have to be in that community. And the process is to say, it's a little bit of a narrow process to say that the information in the MES isn't accurately or fully reflecting the burdens in this community. And that's what they would come and petition the board for and say, we should be treated for purposes of this particular project. We should require, the board should require the applicant to do a CIA report because the MES data, it doesn't quite reflect our community. So it's meant to be somewhat narrow to address a particular situation with a particular project.
Yeah, I'll just add that it is meant to be for extraordinary cases. I'll just highlight that it does need to be for extraordinary cases only. And so, for example, one example could be that there is something new in that community in the past year or two or whatever time frame that is not reflected in the data or in the indicators. Another example we've thought about is if the data is not granular enough to reflect, but it would be up to the community to sort of provide that. But again, it would be only in extraordinary cases and only for that particular project to request a CIA, not to sort of change the whole burden area designation.
Okay, thank you. Is there in terms of the guardrails that are in place to ensure that this is used appropriately, right? If there truly is some sort of new condition or condition that isn't fully reflected in the data set, and not as a tactic for delay, as we all appreciate it could be. Is there some sort of, is it a 10 citizen petition? How does the community, what consensus does there have to be in the community to apply for a CIA to be performed if they're not in a burdened area?
So only a defined key stakeholder that's in that particular SGA can apply. So it's limited to the location and it's limited to the entities that can petition and say, we should get a CIA for this particular area. Now, there's 2 paths that could take. If that happens during pre-filing and the applicant says, sure, I'll do one, then the CIA report would get filed with the application and would go through the regular process with any other census block group, right? Or if the applicant does not decide to agree to do the CIA for that particular SGA, sorry, I'm using too many letters here, then the director of the board would make a fairly quick decision as to whether or not a CAA should be required for that particular area because the existing MES map does not really truly reflect the conditions in that area. And again, trying to keep the option open, but very well defined and narrow to who can request it, where it has to be, and what kind of information they have to provide.
Thank you. That's very helpful.
I just have a follow. As I heard Commissioner Heupel's question, she was also asking about the mechanics of then what does the applicant do? Like, how are they actually doing the cumulative benefit analysis or cumulative impact analysis when most of it is done based on the criteria that has determined that they are not a burdened area?
So they would need to go and do an impact analysis on whatever the elevated indicators are in that area.
But if there were elevated indicators, so, okay, I understand.
Again, the MES, remember, the MES is a composite score. It's not based on an individual indicator. It's a composite score again across 30 indicators. So even if I'm not a burdened area, there might be elevated indicators in a particular area.
I see. Okay.
So if to play it out even further, if it were a clean energy facility, they would need to do the cumulative impact analysis on the elevated indicators. If it were a fossil fuel fossil fuel facility, they would have to do the cumulative impact analysis on all the. And that's how we have tried to reflect the fact that fossil fuel facilities tend to have much larger impacts than clean energy facilities.
So when they go through and do, just to continue the conversation now, so when they go through, I think it's helpful that it's, new information or the data set was old and we have better information. If they, using your example, if they look at particulate matter, they say what's in MES does not actually reflect here. We as a community have better data. Here it is. We say, okay, you've demonstrated that you deserve a cumulative impact analysis, even though you initially didn't qualify for one. Does the applicant then have to use that new information for its CIA, or do they use the existing information that was in MES that initially disqualified the community?
I would suggest that they would use the new information, but we didn't get down to that level of detail in the regulation.
Okay. No, I know this is underway, which is why I was just wanting to make sure that I understood what's available now.
Again, I think either the data is faulty or older, as Undersecretary Power indicated. Maybe something new is built, like a distribution center, right?
Mhm.
An Amazon distribution center shows up in a community. That's a lot of traffic, right? That's a lot of vehicles, and perhaps that would influence whether or not an additional facility put next to the Amazon distribution facility maybe needs some additional review.
Right. And I think our question is just then, as an applicant, are you using the data the community has put forth related to the new Amazon distribution facility in addition to what's reflected in MES? How are you accounting for that in performing
It should
CIA?
be the full set of information. Yes, I think that makes a lot of sense.
Okay. Thank you.
Perfect. I a lot of the same questions in the same area about petitioning that I don't fully understand. So who has standing to petition?
Key stakeholders, which is a defined term in our regulations.
And that is, just to reiterate.
I'm sorry, I don't have that right in front of me. Just one moment. It includes community groups in the area. It includes the local government. There's more specific. We'll get you the exact definition in just a moment. I don't have it in front of me.
Okay.
Can we come back to it?
Yeah, we can come back to it. So, I just think about places like 40B or maybe the casino in Everett, where neighboring communities are concerned about potential impacts. And are there mechanisms across state government in other places that have a similar trigger? Or is this unique where you get to, quote, petition?
So the mechanism that's developed here is specific for this, for a review of a clean or fossil fuel energy project. So whether or not there's other agencies, perhaps DEP, that have similar types of triggers, I'm not aware. But this particular trigger we developed such that understanding how important MES is to the CIA analysis and the fact that the MES will never have perfect data. It gave an opportunity for a local community to say, hey, the data is not right for us. And we have some updated data to provide that indicates that we should get a CIA. He's back there, sorry.
Just, I
Yes,
think one of the things I'll highlight that we are considering is the burden of proof would be on the petitioner, right? And it would be, again, limited by those two factors. You still have to be within the SGA. And You still have to be within the SGA.
Still has to be
Oh
within.
my gosh, I forgot the second one. But
It has to be a key stakeholder.
and have to be a key.
Where and who. Is the
Right.
main-
And the CIA is something that's already outlined how to do and what to do. It's more this community would have to prove that there's an extraordinary reason, but then they would go about the CIA same way the CIA is done.
Mhm.
It is required.
Not to pile on too much to answer your question, Mr. Gutro, but there is actually a similar mechanism right now in the environmental justice area. So environmental justice populations are defined in statute in the 2021 Climate Roadmap Act, but there was a provision that was included in the legislation that also allowed for a group of, I think, 10 or more residents to petition the secretary to be considered an environmental justice population for somewhat similar reasons, that the data was a little too coarse to sort of identify a population that might have been, kind of mixed in with a larger population and therefore not given that treatment. So there's some precedent for it in that as well.
Thank you.
I think just our application here will be more narrow because it will be project specific. It will not turn that area into a burdened area going forward. It's just project specific. We try to be more narrow.
Again, amazing amount of work done by a variety of agencies working very closely together, and it's been impressive to see. It seems to me that the massive virus screen is sort of the Rosetta Stone for which this sort of process is going to work through it. And I have a couple of questions sort of on the sort of pragmatic sort of nuts and bolts of how an applicant is going to get it done. So if the applicant knows the geographic location of the project or options there, and so they can look at the massive virus screen to identify whether there's in a burned area or not, pretty simply, and then they'll know the 30 indicator scores right off the bat. Is that? And then,
Yes, thank you.
okay. Do we know what percentage of census tracts in the Commonwealth will be burden areas based on the criteria?
34.5.
So we do. That's impressive. And then the applicant will sort of go through those 30 indicators and determine whether the project in question has an impact, positive or negative, on those indicators.
On the
Elevated indicators.
On the elevated indicators, that unless you're a fossil fuel facility and you'll look at all.
Got it. Okay. And then I guess
Quick clarification though, am I right that the tool is going to tell you what is elevated? Correct?
Yes, it will.
You're not going to have to do anything.
The tool will tell you what's elevated. It'll give you a percentage and it'll tell you where the data came from. It's pretty robust that way.
And then the data will get updated periodically once we figure out sort of what the rhythm of that is.
Yes.
Great. I think as we look at all this, and I think this undersecretaries and Joan, you all put forth the sort of the context under which we're doing this. There's a lot of change happening and a lot of moving parts and regulations that across the board. And I want to make sure that we're thinking about the pragmatism of it all and making sure that we are achieving, the goal of getting good projects built in a sort of responsible and speedy timeline. And while at the same time protecting, burden areas and making sure that we're doing it thoughtfully. But I want to make sure that we're thinking sort of holistically about all of the impacts that are being sort of thrust upon all stakeholders, developers, participants, cities and towns, and us, frankly, the board and the staff, as we look through this. And so that's sort of a contextual comment that I wanted to make sort of at the beginning of this process, because it is a lot that's happening, and we want to make sure that we're achieving the goals of the legislation at the end of the day. So I want to make sure that we're thinking about the end game.
And I'll add to that as well. I think before we vote on any final regulations, I think we need to see somebody walking through this whole thing. So I want to, see up on the screen how an applicant would actually go about doing all of this so that we understand what we're requiring of people. And because I think there is a lot of confusion about this looks really complicated on paper. Like when you read the regulations, you're like, whoa. But I think, at least the way I understand it, is most of this is going to be very mechanical. And the actual time that it will take to do this, it's not like doing a draft environmental impact study, right? It's a plug and play kind of system that we're trying to set up.
That is correct. Certainly at the MES stage and having the data and tools available to determine which path you need to go on in your analysis. If I'm the developer, which path do I go on the analysis? Do I need a detailed analysis because I'm intersecting a burdened area, or do I need a much lesser analysis because I am not intersecting a burdened area? I will say on top of all of it, though, just to keep in mind too, is that whether an applicant goes through the detailed process or the other process, the board still has that broad jurisdiction to look at all of the impacts when the board considers the overall consolidated permit. And of course, those consolidated permit reviews have very definitive timelines.
Yep.
Just as a context also.
If I could just make one point, I don't want to oversell what we're proposing in this regulation. And there's definitely a significant plug and play, as you call it, component, using the Mass EnviroScreen tool, which is very mechanical and gives a score, and it's very precise using the data that it has. The part
Similarly with the site suitability criteria, right?
Exactly. The part that is a little like an environmental impact review and somewhat subjective, admittedly, is the part where the applicant has to then evaluate the elevated indicators in the burdened areas to see whether the project does something incremental that could worsen an already elevated indicator. And there's no plug and play for that. That is like an environmental impact review in the sense that they have to evaluate how the project is being built and how it will be operated, and gauge the significance of those impacts. So that's not a mechanical calculation. I wish we had a neat computer software program to answer that question, but we have not developed such a thing. And it's a nice idea for the future, but that may require a little more AI than we have right now. So we're working on it.
No, I appreciate the clarification. I understand that. Yeah.
Thank you.
Commissioner Mahoney?
Thank you.
Do you want to, we can give you a definition of key stakeholder thing. Daniel. I don't need my glasses on for that. Okay, to answer the question about key stakeholders, there's a whole definition in the regulations. Key stakeholders mean, at a minimum, public interest groups, organizations serving the local community in the vicinity of a proposed project that could be affected by the proposed project, including project abutting residents, both owners and renters and businesses, community-based organizations, elected or appointed municipal officials, and other relative municipal officials, and representatives of labor groups. Federally recognized, state acknowledged, or state recognized tribes with a presence in Massachusetts. So again, it's a broad group of people, but they have to be concerned with the particular SGA of the project. And that's what's in the regulations right now, that the proposed regulations.
And just to clarify, that definition is in the pre-engagement regulation. It's not in the CIA regulation.
Thank you. So I think a lot of what we focused on today has been when you're just dealing with one project, one at a time, maybe, and how it all comes in. But there are going to be circumstances where there are multiple projects proposed in the same area. Could you clarify for us, maybe just give the elevator pitch about how the CIA will treat what multiple projects coming in at the same time for the same geographic area, both in terms of, I'll start there.
It's a great question. That's always been an issue anyway. It's not, it's actually a bigger issue than that. It's also the issue of what are the ongoing activities in the area that may have an effect on that, like, you know, other corporations, other industries, other effluents, other emissions, things like that. And one is, it's one thing to know what's already there and emitting or causing some kind of pollution or health effect. It's another thing to come up with the probability that a co-developed or otherwise developed project is actually going through. We have, for example, we have experience with things like it was a sure thing. It was definitely going to happen. And all of a sudden, for example, an administration changes or something happens and all of a sudden everything is different. So there has to be consideration with probabilities of impacts. Certainly some things look more sure than others. And so maybe given more weight. Some things are just on paper. And well, in 2032, I think we're going to build a shopping mall. Well, maybe you're going to build a shopping mall in 2032 kind of thing. So we have to also consider we do try to consider everything that's going on in the area that, you know, especially the ongoing things. The things that are, shall we say, proposed or on the drawing board, we have to give appropriate weight to that too. We may say, hey, this is a consideration. You know, it looks like they're going to build a dog food factory in a year, and this is what we think would happen if they did build the dog food factory in a year. So we consider it, but we have to give the appropriate weight to it too, because it doesn't happen unless it's a sure thing.
I think there's two pieces. The piece that Tim was talking about, and that's a kind of a broad piece about what else is going on in community when a particular project is being proposed. But I think there's also a more narrow piece, which is the CIA. The CIA is based on the Mass Enviro screen. It's based on the burdened areas to be updated on a regular basis, right? That data to be updated on a regular basis. But whether or not there's another, let's say, energy project cited in that area, if it's not on the Mass Enviro screen, at least as a first run, it's not going to be picked up as something affecting the burdened areas, affecting the score of a burdened area. But if there's a new project that's being built that's going to affect folks, again, there's this petition mechanism. They could come and say, hey, I think that there's more than one project going on in our area, and we think you should require a CIA report for this area. So it's a kind of, there's the broad question, and then narrow. And narrow is not really necessarily going to look at another clean energy project. They're looking at mostly existing burdens, environmental polluting burdens, and socioeconomic factors.
So to clarify, if you've got, say, 3 solar projects proposed in one community, it's going to be up to a petitioner to flag that to get it into the CIA?
So I think for most solar, which are clean energy, they're not going to, that impact is not necessarily going to show up in the CIA. It's not causing pollution per se. And so it wouldn't show up in the CIA. It may be reflected at times in site suitability. I think maybe Undersecretary Judge could expand on that question, possibly.
Making sure I understand the question exactly. So what, can you just repeat that, or the?
I'm not asking about, it's okay. You don't have to answer for site suitability.
Okay.
I'm good.
Yeah. Okay. Just concerned about the CIA.
Yeah. Okay. And I'll just close by adding my thanks to everybody else's thanks, especially as we have, we've said it before, but the collaboration between EFSB staff, DPU staff, and DOER has been exceptional, along with everyone from EEA in the last 8 months. So well done to everyone, and keep at it.
So I think we'll take a break now. I think there's still some more questions of the board. I know I have a few. I know Commissioner Rubin does as well. But why don't we take a break? How long? We'll come back at quarter after. Thank you.
Okay,
Okay.
we're good.
All right, let's continue with board questions. Commissioner, do you have questions?
I do. I also want to make sure we have time for comments. I'll be quick. In the last section of the regs, 980 CMR 15.11, we're talking about the board's review of the CIA and site suitability. And I know there's discussions about kind of the board considering whether there's been a community benefit plan or a community benefit agreement and the relationship between that sort of fact, yes or no, and also whether to impose additional conditions on the project applicant to address any disproportionate adverse effects. So I would love for staff to just kind of talk through when we don't have a community benefit agreement before the board is deliberating, which I think is most likely to be the scenario, how the board and the staff would advise the board on sort of negotiating the mitigating conditions versus what might be in a community benefit plan.
So thank you for the question. I think the way the regs currently lay out the community benefit plan or community benefit agreement, it would be evidence of what the applicant has agreed to do for the community, in addition to the mitigation of the particular project impacts. So therefore, if a community benefit plan or community benefit agreement were not part of the record of a case, there would be no record then of additional benefits to the community, and that would be something that the board would consider, that there is no agreement or no record of additional benefits for the community, and the board can deliberate on whether or not those kind of benefits would be appropriate.
That's great. And then any conditions would then be imposed by the board would be enforceable by the board. So if there's an issue sort of down the line, then the board could step in. Is that accurate?
Any conditions imposed by the board are enforceable by the board or by the particular agency for a consolidated permit, but the particular agency that would normally have jurisdiction over that particular permit, as the act does require enforcement to go back to specific agencies. I would say that any conditions imposed by the board obviously need to have a nexus to the project impacts.
Excellent. Thank you. Yeah, go ahead, Secretary.
Anybody else have questions? Okay, I just have a couple. Just as by way of clarify, make sure I understand. Attachment A and B is an attachment to the decision, not to the regs, correct?
That's correct.
And so those documents are being published with the decision and potentially also people could comment on it as well?
Yes. And that's one of the reasons we've included them in the package that you have today.
Okay. And on the attachment B, that sort of list of things to consider, I understand the thought behind it to try to provide a little bit more guidance in terms of how people should be looking at the issue. But it does leave a little ambiguity to meet with me about sort of for a petitioner to understand how they're supposed to use that document. I mean, if you're looking at it, do you think, oh gosh, I'm going to go through each one of these and like provide something to the board showing that I meet them or don't meet them? Like, what is it that a petitioner is supposed to do with that list?
So I think that the list in attachment B is to help provide factors that a petitioner should consider in whether or not the impacts from its project materially exacerbate a existing elevated indicator. Obviously, that's a fact determination that would need to be made during a proceeding. Petitioner can allege yes or no. Other parties to the case could agree or disagree. And so this was it's not an exhaustive list it's not a requirement that it's a checklist that the petitioner has to check off each issue, but it's to provide some guidance to how to make that fact determination of whether this specific project materially exacerbates this particular particular elevated indicator.
Nobody's going to have to file anything that says, I went through this list and this is, I looked at 2 and 3. It's going to be just sort of, this is food for thought for you
Yeah,
to
this
think
is food-
about.
Yes, this list doesn't appear as a checklist as part of the template. Does not appear as a checklist as part of the template. It is intended, well, maybe more than food for thought, but yes, it's intended for considerations for the applicant to give something to look at to kind of figure out whether or not those project impacts would materially exacerbate the elevated indicator.
Okay. And on it was mentioned that both guidances still have some issues that are being worked on. Does that have any impact on the draft regulations?
The OEJE and the EEA site suitability, there are, I think, adjustments being made. The current regulations reflect where those are right now, where those draft guides, and we don't go into anywhere near as much detail, obviously, as these guidances do. If the guidance were to change significantly, it could be that it could impact the regulations, but the regulations, certainly on the site suitability, are very high level. And maybe Undersecretary Judge wants to talk about that a little bit more.
Yeah, I can say we've had a lot of conversations with the siting division folks and DOER, because DOER's regs are now at TUE as well, and so we had to make some decisions on what goes in the regs versus what is in the guidance. And so we focused really on what needed to be in the regs in terms of decision points that we had to make. And so it's a lot of the process related steps and sort of the outcomes. Or like if you have a bad score in a particular area, what does that mean? That's sort of reflected in DOER's regs and their guideline on mitigation, on avoidance, minimization, mitigation, which they had put out an earlier draft version. They will put out another one. So for comment very soon. So I don't think any further changes we make to the guidance should have any major impact on the regulations, because we really focused on what we felt needed to be in the regulations and tried to kind of accelerate the review of some of those aspects of the guidance.
Understood. Okay.
I will say the OEJE guidance or guideline changes are much more limited at this stage in the game, what we've seen, than what the site suitability changes to there. And also the site suitability document came out September 12th. So it's older as far as the draft version that's a public version is, I believe, September 12th, whereas the OEJE draft version came out October 31st. So it's much more recent. And there's really, the changes that we've seen are not so significant that they would impact the regulations.
And the site suitability analysis not being required by legacy projects, it was alluded to that that's a statutory issue. How does that work?
That's correct. The site suitability provisions in the act only apply to clean energy infrastructure facilities.
Yeah, it does. It doesn't mention fossil fuel or legacy facilities. It just says clean energy infrastructure facilities.
Okay. On the site suitability mapping tool, is that available for people to see?
A draft version of it is with 4 of the 5 criteria specific categories mapped. So we are trying to finalize the data source, the underlying data layers, so that we can get that to EEA GIS so they can build a more functional version of it that incorporates the public feedback and the changes in response to public feedback. So there is a version of it online that you can access. It's not fully complete. We've done some work, and the EEA and DOER teams have done some work to kind of look at, okay, well, how would project score? So you can use all the data sources that we point to in the guidance now to see and evaluate how sites would likely fare. But we plan on making that a lot more robust in the next month or 2.
There was some mention earlier of the possibility of adding additional indicators. Is that really happening?
I mean, they're being considered. We so far, from speaking to GIS and the professor from Salem State, it would be hard to find sort of, yeah, to include that. So we're considering it, but it's looking like the indicators will stay as they are, the 30.
I mean, it's, there's so much that sort of center around that mapping tool, that having some clarity on that, at sooner rather than later. Because when you're looking at these regulations, you want to know what it is you're actually telling people they have to do. And if you don't understand what the indicators are in the map, that's a different, situation. If you think that's going to change, if you don't know what they are.
Yeah, I mean, we can definitely sort of work to nail that as quickly as possible. One thing I'll mention is some of the indicators that were requested have pretty high correlations with some of the indicators that we already have. So it would not be something sort of completely outside of the list, where it would be a totally new neighborhood that has none of the other 30 indicators. So there is a lot of correlation between the ones that have been suggested and the ones that we already have.
And the sort of stakeholder group that you're suggesting that would be sort of monitoring the data, et cetera, what are you envisioning for that?
Yeah, we're definitely envisioning the agencies that have been involved so far, as well as the external stakeholders. So GIS expert, public health expert, as well as utilities, clean energy developers, and environmental justice communities.
Any other questions? So thank you very much to everyone. Really appreciate you answering the questions. I guess I would like to reiterate how in the time between now and the time that we get comments and the time that we eventually get to a vote, I either do a special board meeting or some way of demonstrating to us what exactly it is that we're asking people to do.
And you talking specifically about these regulations?
These
what we're asking?
regulations.
These regulations. Okay, thank you.
Okay, let's go on to other people's questions. Where are we now? We're going to go ahead and start the deliberation?
No.
No. Okay. All right. So we're now going to listen to public comment. So I would appreciate it, public commenters, keep your comments to 3 minutes per speaker, and we'll gently remind you when you get close to that. For those on Zoom, if you could unmute your microphone, turn on the camera if you like, and state and spell your last name for the stenographer. So we're going to begin with public officials. Are there any public officials who want to ask a question?
Don't see any.
It's Michael. There's two hands.
Sorry. Brian, could you undo that timer? Okay. Sorry. Oh, yes. Okay, I'm going to promote Michael DiChiara to the panel.
Okay.
There he is.
There you go.
Can you all hear me okay?
We can. Thank you. Thanks for joining us today.
Sure. Thank you for doing this. So my name is Michael DeChiara. It's DeChiara. I'm on the Planning Board in Shutesbury and chair of the Energy and Climate Action Committee. I guess I would join people in appreciating all the work that's been done, especially in the short time frame. And listening to the presentations, I do appreciate the openness to changes regarding site suitability. So it's great that every site is going to be required to have a site suitability assessment. That was a huge issue that I was concerned with. So that's great that that's getting addressed. The removal of the application of the total score, that's encouraging. And the removal of the climate resilience factor, I think that's good. The way it was currently set up, looking at flooding for the facility seemed quite limited in its utility. I asked how a project would affect climate resilience of the communities that they're in is actually something that would be worth factoring in. So just on that. I was going to say I was appreciative of the openness in terms of cumulative impact, but the most recent comment makes me actually concerned that it sounds like there will likely not be any additional new indicators. I think it's really critical that the number of clean energy facilities in the community is an indicator. And I'll get to that in a second. It seems like just as human beings, we're usually, we're looking for quick fixes, things that do it all. And so there's this temptation to say, oh, the MES is going to be, you do a polygon, you get a score, we have a score, it tells us everything we need to know. I think this is temptation, but problematic in that we have to look at the underlying data. And although there's 30 indicators in the MES, they're skewed to EJ communities and low-income communities. And in the presentation, I think at Pittsfield, we were told that low-income communities were added as indicators because it was so Eastern Mass urban oriented, and that by adding low income, you got communities such as Pittsfield and Fitchburg or Gardner included. So we had cross the state representation, but what it leaves out critically is rural communities. And I would just point out, even if you added one clean energy indicator, that would be one of 30. Almost by definition, rural communities would not be included in the MES in terms of getting a score that was high enough to be considered burdened. And I guess I would offer up that what we're looking to see is, are communities burdened, and expanding the definition of what burdened is. According to my communications with the town planner in Charlton, which you all know from has a rest up on the Pike, so Central Mass, they have 30 solar sites. I would argue the 30 solar sites in one community is probably making them burdened and insufficient. One other point, and then I have two quick questions you can answer. The discussion about this petition pathway, it seems like based on what, the responses the staff has given to the board, it's getting narrower and narrower, that the information has to be incorrect or insufficient. I would actually push it the other way around, especially if we're not including clean energy facilities in the 30 indicators. But even if we were, a town like Charlton would want to raise their hand and say, hey, we're not represented, but we are burdened. And so you need to have something. Those are facts that are there already. And then the two questions I have, I do appreciate that EEA and OEJ are looking at changing comments, but how as the public do we get to see what those are and be able to comment on them, whether they're in the regs or the guidance in time for February 12th? It seems like we need some sufficient time to know what they are, even if they're moving. And then the other thing that has just puzzled me is the way you all have structured this. EFSB has got the large projects and DOER's got the small ones, and you're both pointing to EEA's site suitability and OEJ's cumulative impact, but they're by reference. And so they're not real. I'm guessing the lawyers can speak to this. If it's in reference in the regulations, if something changes at site suitability and cumulative impact, your regulations will change. But it seems like we should be, if we have things to advocate for, the substance of the changes have to happen at EEA and not at the EFSB in terms of this conversation. So those are my comments. Thank you very much. I appreciate it.
Thank you very much. Go ahead.
Do you want me to answer any of those questions? I would just note the last question. I would like to note that about process. So as far as the regulations are concerned, I'll jump through the steps. The regulations, any changes to the regulations, once they're finalized, has to go through a full regulatory process. So that means we have to start over with what we're doing now and have, proposed changes and file them with the Secretary of State and provide notice and hearings and draft regs and final regs and all that type of thing. So that's one set of opportunity to be heard when the regulations change. Taking a step back, anything attached to the TD, anything attached to a decision of the board, that would be the board, the citing board's guidances would be changed after a decision of the board. So that would, again, we would have to put out the changes. We would ask for, ask comments on it. Folks can comment at the board meeting, and those would be changed by order of the decision of the board. As far as the guidances put out by EEA and OEJE, I am not exactly sure of what once they're finalized, what the update process will be. And perhaps one of the undersecretaries could speak to that.
Yeah, so we got some comments on this on this with respect to site suitability, at least, and we plan to clarify in the guidance that we will conduct a review of the guidance and how it's working at some point in the future. Right? So have like sort of a time constraint there. That doesn't limit us from doing something sooner than that. We may, in fact, come and look at it sooner. I think there's, we don't necessarily expect to get everything right out of the gate here. I think we're making a good faith effort, but we'll have to see how things are working in practice. We also have intend to put some clarification in there around how and how frequently the underlying data sources that produce the scores will be updated. So we do plan to speak to some of that in the guidance.
If I can just quickly follow up, just since this is an EFSB hearing, I mean, the substantive work in site suitability or cumulative impact is work getting done at EEA. And so what's unclear is that the EFSB regulations are pointing to those two documents and saying we're basically taking what's been created by EEA, the rules of the road, and incorporating them into our regulations. But if EFSB and DOER had separate issues with those two things, since they're pointing to it, it's really up to EEA to make the changes, right?
What do you mean issues? I guess I'm not.
Well, EFSB could have an opinion about some small issue in site suitability that might be different from an issue that DOER might have about site suitability. They're both pointing to the same thing, but as independent agencies, they might have different interpretations. But because they're not the quote unquote owner of site suitability, EEA is, neither DOER or EFSB can independently change anything. They sort of it's got to happen at the EEA discussion level, I would think. It's just it's unclear because you're pointing the way you divide it. You're pointing to two products. Two different agencies are pointing to two different products of policy, and they're not creating it and they're not going to change it down the road, but it's incorporated in their regulations. So it's just sort of confusing as to where one directs their attention. If that's clarifying.
So this is the way the act is set
Yes, the
up.
statute sets it up that way.
The act is set up such that there are 3 guidance documents required by the act, which is 2 by OEJE and 1 by EEA's, the site suitability crew. They set the general policy in those acts, and then then the act requires this agency, DOER, and DOER to promulgate regulations that are consistent with those guidance documents. So
I'm a little worried about
right now.
I'm a little worried about time, so I want to move on to the next person. Who is up next?
Cliff Carroll. I'm assuming that he is. Mr. Carroll, I assume that you are a public official because that's the group that we're hearing from right now.
Hello, this is Cliff Carroll. Can you hear me okay?
We can, thank you.
Okay, thank you very much and appreciate the opportunity to speak. Um, in reference to this overall bill that's going through, I think what this is going to do is actually complicate, and as the gentleman who just spoke before me was saying, I think that some of these scoring systems that you're referring to don't quite take into consideration outside issues. And I don't know where we can find a copy of what the 30 standards are on your scoring system. My bigger issues are I'm down here in Cape Cod, Massachusetts, and I'm in a town called, Barnstable. And when you talk about cumulative effects and the problem that we have with these consolidated permits that override all local jurisdiction, basically, what has resulted here in the town of Barnstable is we are on a sole source aquifer, which is very similar to your Quabbin Reservoir up there as far as your sole source of water goes for the city of Boston. We have ended up at the town of Barnstable because of where the cables are coming in with the 3 onshore transformer substation sites. Each location has been put directly over our town well fields and our sole source aquifer, with the cumulative effect being one site has 100,000 gallons of transformer oil. The second one has 125,000 gallons of transformer oil. And the third one has over 200,000 gallons of transformer oil proposed for the third transformer substation. When the state overrode the town of Barnstable with the original EFSB consolidation permit, they not only wiped out local conservation, they wiped out all local permitting, they also wiped out our ability to force a bond, the discussion of our sole source aquifer, what would happen if there were a catastrophic spill. And in reference to decommissioning, I see that you ask in here that you would like them to present some type of plan for decommissioning, but there should also be information in there about the actual bonding and who's going to be responsible for the cleanup. In addition to your mapping tool, I haven't been able to find it, but I don't know if it takes in well fields, aquifers, farmland, historic properties. Electromagnetic interference is becoming a huge issue for the cable that has already been installed down here. And since the agreements were done, we haven't heard back from the developer. We haven't had him come back to our town. He hasn't spoke. They're just completely not cooperating. So is there any type of forceful cooperation mandating continued conversations with the towns that are a host agreement? And my last question is community agreement. I've heard that mentioned multiple times. They were able to do that for the first project. Then they were able to do it for the second project. But the town of Barnstable has voted overwhelmingly, the town selectmen, and ordered the town manager for the town of Barnstable to inform the wind farm developer that in no way, shape, or form do we want the third project coming through the beaches of Osterville, coming through the roads of Centerville, and or ending up on the 200,000 gallon site, which is 28 acres of one of the highest points of land in our town. How does this agreement or this consolidation bill that you're passing, what happens in the event where you have a town that refuses to sign a community agreement and absolutely is asking the town not to allow this permit in any way, shape, or form? I don't see any place where there's mitigation for that. I don't see where the towns are allowed to have any actual say in the matter. And I know this is going on across the state with solar farms and battery facilities also. But my main concern is the 400,000 gallons of oil proposed for our well fields here in Barnstable and the developers' complete ignoring of our ability to bring it up, discuss it, and then in turn, the state did the exact same thing when they passed the consolidation of ESB rulings where they took away all local permitting and all local say in the matter. And I
Mr.
just
Carroll, thank you very much for your comments.
Thank
We're going to
you.
move on because we don't have a lot of time. Thank you, though.
Appreciate your time. Thank you.
Oh, sorry. Yes. Okay. Now anybody who is left who still wants to do comments? Mr. Long.
Hi, I'll be brief. Steve Long with the Nature Conservancy in Massachusetts. I'll echo thank you. Having served on the commission, worked on the legislation and the regulations, you all are doing amazing work. So I think that one of the things that we're really hopeful for is looking for no net loss, nature positive, and thinking about ecological equivalence, not just ecosystems, but their functions as well. And there were a couple of topics I wanted to explore. One, I think Michael DeShara had a really good point about climate resilience. It's really about the impact on the community itself. Would the facility exacerbate flooding if there is a concrete pad on which solar panels are sitting? What would happen with the stormwater? And I'd like to explore making 15.10 a little more tangible relative to site suitability. There were two portions of that. In section 2, it says the developer or applicant shall present a score to the community. I'd like to see that language expanded to include the details on how that applicant plans to avoid, minimize, and mitigate their impacts. And then also on 15.10.6, it's not clear. It sounds like it's a binary decision, either issue the permit or not. And I'd like to see some language that allows EFSB to apply some conditions and requirements on the permit. And this is more of a question. Site suitability relates more to the science, using science to identify variables. And at one point, we were talking about threading together and weaving together the science of site suitability and people's lived experiences in the community. And I can think of an example from an MVP, Municipal Vulnerability Preparedness Program, process in which I participated. The science was helping identify where flooding was predicted, but the people in the community know where flooding happened historically, which was different than the predictive model. So I think if we can figure out how to weave those two together, we'll have a much more added value process. Thank you.
Thank you. Anybody else?
Hi, my name is Adam Reynolds. I'm a legal fellow at the Conservation Law Foundation. It's ADAMREYNOLDS. And I just wanted to express CLF's support for the work that the EFSB and your agency partners have been doing to draft and release these regulations governing cumulative impact analysis. We think these are an essential part of designing a new regulatory framework to promote an equitable transition to a clean energy future. And the regulations really codify EFSB's commitment to accounting for the many burdens that communities face and are designed to ensure that project applicants address the harms exacerbated by those projects. And importantly, we really want to express our appreciation for some of the changes that have already been made to the regulations, especially including legacy fossil fuel projects and the ability to account for all indicators that are impacted by those projects. And going forward, we're excited to continue to work with you in the coming months to build on these regulations, particularly to ensure that the initial screening tool effectively identifies all EJ communities. The communities have a role in the identification of the burdens that they experience through the CIA process, and that the EFSB is fully empowered to consider those identified impacts in the decision-making process. And I think the conversation that happened earlier today about how to use the data that comes from communities when they're identified for a cumulative impact analysis, if they aren't initially identified as a burden community, was a really productive one. And we support continuing to think about where that data can come in. And also along the lines of the indicators and the questions that the secretary was asking about that. I think we had highlighted that in the DEP cumulative impact analysis, there are a few indicators that are included there that aren't included here, where we hope those may be easy indicators to pull in because of their statewide availability and their use by other state agencies. But overall, I again want to stress that we are very grateful for all of the work that's gone into this. And we think this is a really important part of this process. And we're excited to see it moving forward. And we look forward to continuing to work with you in the future. Thank you.
Thank you for your comments. I think we have one more comment online. No. Okay. So we are ready to deliberate. To begin deliberations, can we have a main motion before us, a motion to adopt the tentative decision?
Yes, I move to adopt the tentative decision and the attachments.
Second.
Right. Deliberation. Anybody comments, questions, amendments? I guess I will say, I am happy to vote yes to adopt the tentative decision today. I am looking forward to seeing the continuation of the good comments that we've been getting and continuing to make sure that we come up with the best product that we can. So I am in favor of adopting the tentative decision.
I'm happy to jump in. Just, I agree with you. I'm also happy about that. I think we got a couple comments today, including from you, Secretary Tepper, about wanting to understand how to walk through doing the CIA report. And I'm actually thinking perhaps, sorry, I haven't talked about this with any of the staff, but perhaps at our upcoming public hearings on February 2nd, we can sort of have a walkthrough of the updated version of the Mass Enviro screen and how the CIA report would work. That might be a good opportunity to then get further comments that will inform the subsequent board meeting when we next meet to talk about this.
Okay. All right. I think we're ready for a vote. Can we have a roll call vote, please? We have a motion on the table to adopt the tentative decision.
All right, we'll take the roll call vote. Chair McDermott,
Yes.
Commissioner Rubin,
Enthusiastically, yes.
Commissioner Mahoney,
Yes.
Commissioner Heipel,
Yes.
Mr. Gutro,
Yes.
and Mr. Bonfilio on Zoom.
Yes.
Thank you. Chair Tepper.
Yes.
Motion carries.
All right. Thank you very much. Can we have a motion to adjourn?
Enthusiastically motion. Move to adjourn.
Second.
We have a roll call vote, please.
If necessary. Okay. Chair McDermott. You got to vote again.
Regrettably,
Voting to
yes.
adjourn.
Commissioner Rubin.
Yes.
Commissioner Mahoney.
Yes.
Commissioner Heipel.
Yes.
Mr. Gutro. Mr. Gutro, did I?
Yes.
Oh, you did. Okay, sorry. Mr. Bonfilio.
Yes.
Chair Tepper.
Yes. Thank you all very much. Thank you for your time and for all the staff's work today, and really appreciate all the work that you have done and look forward to seeing what comes next. Happy holidays.
Likewise. Take care.